Hello and welcome to the Rogers Brief for October 29th, 2023. I'm Adam Rogers. Thank you for watching. Thank you for listening. If you enjoy this content, of course, I encourage you to like, subscribe, share these episodes out and see who else may enjoy them as well. Hope everybody's getting ready for Halloween. Fun time of year. Getting a little chilly out there in Nova Scotia, so we have to bundle up, unfortunately, for some of the trick-or-treating. Some interesting stories to follow this week. We have the tragic shooting in Maine. I'm going to touch on that briefly. Some cases in Nova Scotia. Some interesting. One is a doctor that was sued, and another is an unusual case of the Crown trying to remove defense counsel from a case in Kentville involving a murder. And we have a new Supreme Court of Canada Justice. Talk about that, and some lawyers who have been banned from practicing anywhere in Canada for the next 3 years. So lots to get into. I'm not going to say very much about the shooting in Maine. I'll talk more about that probably tonight on the Sunday night show with Jordan Bonaparte and Paul Palango. We're exchanging emails here this morning about some of the topics, and obviously that's going to be one of the ones that we cover tonight. So invite people to join live on YouTube on Jordan Bonaparte's nighttime podcast channel at 9:15 this evening. So you'll get some interesting conversations about that, some comparisons between the Maine shooting and the mass casualty in Nova Scotia. Of course, people will remember from the mass casualty report that Maine was where Gabriel Wortman acquired his illegal firearms, brought them across the border, smuggled them in, and there was a report issued from Canadian Border Services that said that that was one of the main, pardon the pun, transmission lines, I guess, or pipelines of getting illegal weapons into Canada, because Maine, of all the states, has some of the weaker gun laws in terms of gun control. So we have this Army reservist, Robert Card, killed 18 people in 2 locations. He had left a note, a suicide note, but not much detail as to any motivation. No detail as to any motivation from what's been discovered from what I've read so far. But, okay, so this guy was 40 years old, hadn't served in combat. He was an Army reservist, but not a combatant. New York Times story this morning says that a sheriff, just a few weeks prior to the shootings, a few weeks ago, sent out an alert to law enforcement across the state saying that Card had made threats against his own army base. He was not found at that time, was known to be, or thought to be, mentally unstable. And so there's more details like that coming out. Notable in this sense as well that there's so much more detail in these early days coming out of this situation in the United States than there was in the Nova Scotia mass shooting. We knew very little about Wortman or any of the firearms, any of those things. We have all of those details now about the United States situation. So see what kind of adjustments are made. I see President Biden has made comments, others have made comments about the nature of the firearm itself. It seems that it's the way Maine handles mental health situations. It's very difficult to take guns away from people in Maine. In Nova Scotia, if you're charged and the police feel like there's a problem, they'll just ban you from, you have to sign an undertaking or else you won't be released. In Maine, they need a medical opinion before they can go in and take firearms from people. So different setup there. We'll see if that gets any attention, that element of things, as we've seen in other cases. Okay, more about that tonight on the nighttime Sunday night show. Talked about this case a few times. This out of Manitoba is from a couple of years ago during the pandemic. The Canadian Centre for Constitutional Freedoms, John Carpay was the lawyer most people would be familiar with. The other lawyer involved in this situation was named Randal Cameron, both Alberta lawyers, but dealing with a case out of Manitoba. And it was about pandemic restrictions, and they thought it was going to be a good idea to have a private investigator follow the judge around, Justice Glenn Joyal, who was the Chief Justice of Manitoba, hearing the case. Well, he figured out that this black car seemed to be following him around. He brought it up in court. Carpay identified that it was him that had hired the private investigator, apologized for it. Well, that wasn't the end of it. Carpay and Cameron were subject to complaints at the Manitoba Law Society, and as part of those complaints, they are banned from practicing law in Manitoba for life, and $5,000 fines there each. Now, they had also been charged criminally with obstruction of justice and intimidating a member of the justice system. So by words or deeds, you're trying to intimidate somebody into doing something or not doing something that is in their duties in the justice system to do. So they reached a plea deal, though, where they didn't have to plead guilty. They have a peace bond. But as part of the peace bond conditions, the maximum length is 3 years. They are banned from practicing law anywhere in Canada for 3 years. So serious consequences, but not criminal consequences. No criminal record for either one of them. Came out during this proceeding, the criminal proceeding, that John Carpay had deleted all his correspondence with the private investigator, and Cameron had urged the private investigator himself to do that as well. So we're trying to cover their tracks unsuccessfully, as it turned out. We have in Canada a new Supreme Court Justice, back up to 9 full complement of justices on the Supreme Court of Canada. This is the former Chief Justice of Alberta, Mary Moreau, and Justice Moreau replaces Russell Brown. Justice Brown was removed, you might recall, under pretty questionable circumstances. He was down in Arizona at a conference and was alleged to have been harassing, making sexual comments or suggestions to another guest of the hotel. Never substantiated. He denied it immediately, but then it went to a judicial hearing panel or something, and it was just not going anywhere. He was removed from the Supreme Court of Canada on an interim basis, again with really questionable authority for the Chief Justice to have even done that. And Justice Brown felt that it was his responsibility to step down because, as it was, there were cases not being heard, and it's difficult for the court to operate without a full complement of justices. So he kind of fell on the sword there, probably unfairly. We don't know all the details, but from what we do know, it didn't seem like that he was fairly treated. But that did mean that somebody had to be appointed. And not only somebody, but somebody from Western Canada, Western or Northern Canada. So the way the Supreme Court works, you have 9 seats. 3 are from Ontario. 3 are from Quebec. 2 are from Western or Northern Canada, and 1 from Atlantic Canada. So this Justice Brown was a Western Canada member. Now we have him replaced by somebody who has been a judge, Justice Moreau, since 1994. She's bilingual. She studied some law. She went to the University of Alberta, but did study on an exchange program law in Quebec. What do you need to be a Supreme Court of Justice? The minimum requirements: you need to be functionally bilingual, and you need to be either a judge in Canada or have been a member of the bar for 10 years. So minimum requirements to become a justice, but of course very high standards for those who ultimately make it. Next step for Justice Moreau is to appear before the House of Commons Standing Committee on Justice and Human Rights for a question and answer session. Not like the United States, where you get really vigorous questioning of people in their judicial histories and decisions and philosophies and all those things. Justices in Canada are really more or less expected not to have much of a philosophy of any kind or ideological bent or anything like that. Not like in the US, they want to know, like, are you an originalist? Are you going to interpret the Constitution as it was written, as it would have been interpreted hundreds of years ago, or currently? In Canada, that debate has more or less been resolved by a consensus that the Constitution evolves and everybody evolves with it. So we'll hear from Justice Moreau at the Standing Committee, and if anything interesting emerges from those question and answer sessions, then I'll bring that to you as well. Next story is a big one in Nova Scotia. It made the news this week for a few days, and these are the Crown Prosecutors in Nova Scotia who are raising alarm bells over case backlogs and burnouts, particularly for serious sexual assault cases and homicides. They say that this is Brian Cox, who is the head of the Nova Scotia Crown Attorneys Association, that the system is failing, that it is on fire, that senior Crown Counsel are leaving. My practice, I've noticed this as well and talked to other Crowns that say the situation is really dire in the city, that senior Crowns are either leaving the practice altogether or else going from the provincial Crown to the federal Crown, which pays more and the work is much easier. Provincial Crowns deal with complicated murder, sexual assault, historical sexual assault, everything across the spectrum. Federal Crowns deal with fisheries, drugs, cigarette smuggling, stuff of that nature. Much easier, much less emotional baggage tied to these kind of cases. And so there seems to be an exodus taking place. So we'll see what this emerges. Senior Crown Counsel, by the way, Brian Cox himself, the Crown Counsel, not the Emmy-winning actor, called in 2014, so not even 10 years into practice, and he is the president of the Nova Scotia Crown Attorneys Association. So we'll see. So what it leads to is junior Crowns doing serious cases and or cases being delayed while Crowns become available. We're seeing this throughout the system now. This is, a few months ago it was we didn't have enough judges and those got appointed. Now we're hearing we don't have enough Crowns. Minister of Justice seems to acknowledge this in a sense, but without committing to hiring any more, which kind of leads me to, well, why is this coming to the public as a story? Because the Crown Association is, or at least should be, reluctant to make this kind of thing public. Why? Because it certainly does not inspire confidence in the system. I mean, and this is one of our obligations as lawyers, is to try to inspire confidence in the justice system so that people think, at least, or understand that there is a system there that they can rely on that is competent and can handle whatever cases, whatever criminal matters come before the courts. So this kind of a statement undermines that. All right, well, to what purpose? To me, when I see this, I say, well, they should have tried the quiet route first. Go try to meet with justice officials, talk about the numbers, the backlogs, the problems with, hirings, lack of Crown Counsel. Do that quietly behind the scenes. Well, the fact that this is coming out publicly tells me that that has already been done and it hasn't worked. And the comments from the Justice Minister don't confirm that, but they suggest that that was probably the case, that there was an attempt made to bring these matters to the attention of the government, but that was rebuffed in some way, or else not. The signals weren't sufficient to keep the Crown Prosecutors Association from going public. So we'll see where that develops. Certainly, it's not just the city either, or serious cases. I know in Port Hawkesbury there are currently no Crown prosecutors, usually two. Sydney's looking for Crown prosecutors, Pictou as well. So we'll see how that situation unfolds as time goes on. All right, a couple of cases out of Nova Scotia I want to talk about. One is dealing with a doctor out of Sydney on a really sad situation with a child being born with abnormally high thyroid stimulating hormone. And in this case, so the parents are suing the doctor. This is Dr. Andreas Kachetanowicz. Well, a decision by Justice Patrick Murray after a 12-day trial. Lindsay Jardine and associates from Wagner's out of Halifax for the plaintiff. Brian Downey, my principal when I was an article clerk at what's now called Cox and Palmer, for the defense, for the doctors. The firm that defends the doctors, they defend them to the hilt typically as well, and certainly did so here. So the child, Alexander McNeil, was born, like I said, with abnormally high thyroid stimulating hormone. So what happens then? In Nova Scotia, there's a newborn screening program which tests blood samples for every newborn, and those samples are sent to the IWK for testing. And if there's anything abnormal, so what Dr. Kachanowicz does in Sydney, CBRM, Cape Breton Regional Hospital, he takes all the results. He wants to see all abnormal results, just so he's aware of them. Okay, and he did see this one. But what happens is the IWK sends back the results to the hospital with a note on what the situation is, and then whether the patient is going to be recalled. That's the word they use, recall. So on the report, the lab report included the words, recall has been initiated by the IWK Health Center. So this condition, congenital hypothyroidism, is preventable if it's treated in the early weeks of a person's life, but if it's not, then severe cognitive delays can result in that's unfortunately what's happened here. There were four expert doctors who testified on. All right, so question is, what is the standard? What is the standard for a doctor in this situation? Basically, the question is, when you get that note back from the IWK saying that they're going to follow up and recall the patient for analysis and treatment, are you then obligated to check back in a few weeks or a few months to say, hey, did that actually happen? The two experts the plaintiffs hired said, yes, that is the standard. You should do that in all cases. But the justice, it also came out in evidence that nobody actually does that. So these are the doctors saying this is what should happen, but in fact, nobody actually does that. The follow-up, if the IWK says they're going to call somebody back in, you count on them doing so, and in fact that has always been the case that they have done so. So the court found that this was closer to a standard of perfection than of reasonableness on the part of the doctor, and that was not the actual standard to which doctors must adhere. The judge said this was unexpected and unforeseeable that the IWK would fail to complete the recall, and it was reasonable for Dr. K to expect that they would. So that's how that goes. So doctors get test results back. So this case will be used for other situations, I'm sure, where doctors get test results back and somebody, they're aware of it. Simple awareness of a test result does not mean that you are therefore committed to doing something about it. If you have a reasonable expectation and a history of knowing that other organizations, other entities will. All right, last one I want to talk about, last case is this, it's a case out of Kentville, Justice Chipman decision, and it's R versus Dennis, criminal case. And this was an unusual application where the Crown Prosecutor, Peter Craig in this case, is seeking to remove defense counsel from the case. Now, normally clients get to choose their own lawyers and that's it. The Crown has nothing to do with it and should have nothing to do with it. But rare circumstance here. So what's the background? May 24th, 2020. Daryl Atwell, Devin Dennis, and Robert Campbell, three people go to the home of Rebecca Moyer on Ridge Road behind Wolfville with an intent to commit theft, to steal there. During the course of events, Campbell is shot and killed. One of the three that were going in. Atwell and Dennis take him from the home, take him in a vehicle, take a second vehicle, burn the first vehicle with the body in it, and throw away the firearm, try to hide it. Well, Dennis, the accused in this case, spoke with a man named Anthony Kelly shortly afterwards about the details and about how he, it's the allegation, how he, Dennis, shot Campbell. Mr. Kelly spoke to the RCMP on June 22nd, about a month later after the killings of 2020. But then, before trial, Mr. Kelly dies of cancer in August of 2021. So what happens? The Crown wants to use the statement because it was made to a police officer and, in their view, reliable and the best available evidence of that situation. There's an application for it. It's called a Bradshaw application. If the information is reliable, then it can be used. So, the wrinkle in this case was that the defense lawyer, Zebedee Brown, practicing out of Canning, a solo practice out of Canning down in the valley near Wolfville, 2013 call, so he was 10 years into practice. He spoke with Mr. Kelly, and so it seemed like he had evidence, seemed like he had evidence that was going to be helpful to his client based on that conversation, the reliability of Kelly's account, all of that stuff. So, awkward situation in a sense, because that makes Brown, the lawyer, a witness, and you can't be both. You can't be a lawyer and a witness in the same case. So they had a pretrial, and Mr. Brown identified the situation and said that Mr. Dennis was going to have to find another lawyer. Well, then they come back months later as the trial, as time's going on, and the trial's been rescheduled, and Dennis has changed his mind, or Brown and Dennis have changed their minds collectively. But of course, it's Mr. Dennis's decision. He has the right to choose his counsel. So what the decision was, they were hoping would be that whatever benefit they were going to get from Mr. Brown testifying about what Kelly had told him about the conversation before he died, they were just going to not use that and go to trial and use other evidence and hope for the best, I guess, and they made a judgment call in their view that this evidence wasn't going to be necessary. We don't know exactly what that would have been because that part hasn't been revealed. It wouldn't be. But the judge now, so the Crown didn't seem to like that course of action, and Justice Chipman agreed. So Justice Chipman said, yes, you're balancing different factors here. Client has the right to choose his counsel. Lawyer can't be a witness. But then the judge says, okay, well, this is a pretty important, yes, you might want to make a judgment call, Mr. Dennis, on, whether you want to use this evidence, but it is a very important issue because it goes to whether Mr. Dennis made a confession. And if he made a confession, well, that's the end of the case in a sense, but if not, then, the rest of the case is relevant. So therefore, the evidence of Mr. Brown is almost certain to be relevant to the ultimate case and key to the case. The other problem that the justice identified was that Mr. Dennis, even though at one of the pre-trials, the judge says, okay, well, if you're thinking about not using this evidence, Mr. Dennis, you should get independent legal advice, not just advice from Mr. Brown, who's in a difficult position in a sense because he may want to do the case. It's an interesting case. He's committed to it. He's going to get paid for it. And he doesn't want to be conflicted out by something. So the judge told Mr. Dennis, you should get independent advice before you make this decision. And Mr. Dennis did not get independent advice. And so when he comes back to the hearing before Justice Chipman, that's one of the factors that really weighs against Mr. Brown continuing. So ultimately, Mr. Brown was removed, and so Mr. Dennis is going to have to get a new lawyer. Presumably, Mr. Brown will now testify at the trial if there is one. So this is a really unusual situation, but also an example of how legal and practical considerations can conflict. You know, you have the legal conflicts that are clearly at play here. On the other hand, you know, Mr. Dennis has already paid probably Mr. Brown, you know, thousands of dollars to get prepared for the trial, to work on it to that point. Now he's going to have to restart that with somebody else. Now, whether he's paying or whether it's legal aid, we don't know. But either way, it's going to take time for a new lawyer to get up to speed on that. And so the time and mental resource, at least, has been wasted in a sense by Mr. Brown on behalf of Mr. Dennis. So we'll see if that goes to a trial, what the outcome might be, and be curious to see if that gets to a reported decision, what Mr. Brown and Mr. Kelly actually spoke about. So we'll hear about that in due course, perhaps. Okay, well, that's it for this week. Like I say, I'll be on the Sunday night show tonight at 9:15. We'll be talking about the shooting in Maine. I think we'll be talking about Buffy St. Marie as well. I mean, anybody's been following that case, and some other interesting stories from around the country. So catch you then, and otherwise, thank you for watching, and thank you for listening, and we'll see you next time.